Good afternoon, everyone. Magistrate Pauline Spencer here. Thank you for joining us for the fabulous Lunchtime Consider This series, where we stretch our minds and learn new things, ways of thinking about our work. It is with great pleasure I introduce our guest speaker today, Magistrate Dr. Michael King. Michael is a guiding light in the area of therapeutic jurisprudence, has literally written the judging bench book as part of his PhD studies at Monash University, and has expertise in therapeutic jurisprudence, restorative justice, solution-focused judging, and non-adversarial justice. Dr. King presided over the Perth Drug Court and the Armidale Family Violence Court in Western Australia, and did some very groundbreaking work in Western Australia in Geraldton, applying therapeutic justice techniques in a busy mainstream court in Geraldton, and getting that off the ground with community. And we were very lucky that Dr. King was appointed as a magistrate in Victoria and is currently presiding over the drug court in Dandenong. And today, Dr. King is going to be talking on a topic of agents of change, and about the connection between our very human need to have agency, or be the masters of our own lives to facilitate positive change. So without further ado, I'll pass over to Dr. King.
Thank you, Magistrate Spencer. I really appreciate the opportunity to speak with everyone today. So one of my passionate interests has been therapeutic jurisprudence, and I did come across it when I was the Geraldton magistrate back in the year 2000, ancient history. And what I'm talking about today is an example of therapeutic jurisprudence, seeing whether principles from the behavioural sciences can be used to improve court work, legal work, the work that we do. I'm not a psychologist, I'm not trained in that area, and I know that many of you on the link today know far more in that area than I do. So this is simply the attempt of a scholar and practitioner of the law to link behavioural science principles to what we do in courts. One of the main principles we'll talk about is autonomy, and that's a basic human need that informs our behaviour, and it also informs positive behavioural change. I'll also refer to self-determination theory, which in its formulation sees three basic principles as essential for human flourishing, and the absence of which causing psychological harm. Autonomy, competence, and relatedness are those three principles. Emotional intelligence is about using intrapersonal and interpersonal skills to manage human emotions and interact constructively with others. And what we're about in solution-focused judging, therapeutic jurisprudence, is using largely interpersonal skills in our work to minimise the harm to others and to promote positive behavioural change and other outcomes. And I argue through this presentation that we can use those skills in the context of a court to promote autonomy, competence, and relatedness. And by doing so, we advance justice system goals, confidence in the court system, and more comprehensive, psychologically optimal resolution of legal problems. And we can do so even in what is commonly an adversarial and coercive environment. So lawyers like to justify what they do, so I'll give a short justification. We share, the law and the behavioural sciences share several things. An interest in communication, because that's how we operate, and also in behavioural change, particularly the criminal law and to some degree the civil law, is all about resolving disputes, but also trying to promote change of behaviour in a more supportive direction. And because the behavioural sciences research these areas, then why shouldn't we draw on their findings to see how we can inform our own court and legal practice? And we can do that within the confines of statute, the common law, and the values that we need to promote in our justice system. Therapeutic jurisprudence already happens. We may not necessarily call it therapeutic jurisprudence, but it is there. We just need to look at the change in how courts deal with child witnesses, with complainants in sexual assault matters, how we deal with pre-recordings of evidence, etc. All of these changes have been, and child witness support services in different jurisdictions, and the restricting of cross-examination of child witnesses to age-appropriate questioning. All of this arises because of findings from the behavioural sciences that our processes before that were damaging to children. So us altering them, the legal system altering them, is an example of therapeutic jurisprudence. It doesn't mean that lawyers and judges and magistrates become counsellors. I don't really have time to talk about the ethical boundaries, but at the end of these slides, which I'll make available, there's a reference to an article that discusses ethical boundaries in applying therapeutic jurisprudence and solution-focused judging in solution-focused courts, Indigenous sentencing courts and mainstream courts. I want to acknowledge that all of our court the court programs such as drug court, ARC, career court, I'll put in ARC twice, all of these programs work. KISP is the other one, applying many of the practices I'll discuss. And I also acknowledge the work that many of you do that already apply these principles. And I apologise for preaching to the converted. But I hope that the presentation will be stimulating and give us a framework for reflecting on how we're approaching our work. This is a great quote from a British Russian philosopher. And this theme of liberty, of autonomy, goes through our literature, our political literature, our legal literature, and so on. And it's something that's intrinsic, that's fundamental to us, that we all want to be able to be in charge of our lives, to govern what we do in life, to control our life and not be a puppet of someone else. So the right to control, as I've observed, the right to control our life is an ongoing theme throughout our life, whether it's in politics, culture, spirituality, and indeed in human rights law. Many of the principles of many of the human rights that international instruments protect either directly relate to autonomy or to the promotion of an environment where autonomy can flourish. John Stuart Mill famously wrote his piece on liberty and commented about if you constrain action to something that's contrary to belief, it promotes inertia. Self-government is self-determination is fundamental to the struggle of First Nations peoples around the world. But autonomy is not the right to do whatever we want. We are constrained by our society, by our social norms, and by the law. And I note that therapeutic jurisprudence right from the beginning has emphasised autonomy. Again, at the end of the slide, there's a reference to a wonderful article by Bruce Winnick, which is devoted to autonomy and therapeutic jurisprudence. So I'll be referring to the self-determination theory, and the reference that I rely on largely in relation to that is on that slide. And self-determination theory is about factors internal and external to an individual that promote or hinder human wellness and flourishing. And as I commented at the beginning, autonomy, competence, and relatedness are values that this theory promotes. and sees as essential. And it also asserts that many forms of psychological dysfunction are caused through a vitiation of either one or more of those particular needs. So research has found that if these needs are there, then it supports positive behavioural change, engagement in health practices, improved workplace outcomes, and achievement in educational settings. So programs that promote these sorts of values have those positive outcomes. And where we don't value these qualities of human life, then we have the risk of creating problems in human life. And I'll refer to some of those shortly. So in self-determination theory, autonomy is about managing one's actions and experiences. It implies voluntary action or actions that are consistent with one's values and interests. Autonomy can be limited by external forces or by internal dysfunction. The legal system is one of the great external constraints on autonomy. But also it can come about if someone doubts their own ability to act, if there is other psychological disturbances, then the ability to exercise will freely is limited. And Ryan and Desi refer to the value of acting with autonomy in that quote that I've extracted on this slide. So competence. Competence is the need to feel effective in action, and that factor has been there for some time in other research. Bandura calls it self-efficacy, and again, this has been a constant theme in therapeutic jurisprudence from early days, the need to support people's self-efficacy in the legal system, particularly given that many of our processes over the years may have undermined competence, and people may have received the message through our legal system that they're not competent human beings and they need someone else to tell them what to do. This can be counterintuitive. It can hinder our ability to act if we doubt our own competence, either through the influence of an external agency or through our own doubts and dysfunction. Then our ability to engage in positive action, then that is hindered. So if one's competent, if one feels one's able to act, then it inspires action, and it helps people to engage in positive activity. One of the main theories of criminology in relation to the cause of crime is, of course, labelling theory. And that third point on the slide, persistent negative feedback compromising competence, it rings well with our legal system and our court system, and particularly where people coming through the courts have been over the years told that they're not able to properly function, that they're hopeless, or that they're recalcitrant offenders. This takes its toll on competence and people's ability not only to engage in positive behavioural change, but also to lead a good life. Relatedness concerns the need to connect to people close to us and to wider social groups. It relates to belonging and also being able to contribute. So it's a reciprocal sort of relationship, that connection where one gives but also receives, and one feels a part of a greater whole. Again, with the work that we do, and particularly sitting in drug court and some of our specialist lists, we often see this disconnection between people and the wider society. And I'll refer shortly to work of Shad Maruna, which ties into this issue of disconnection and inability to get one's life back on track. And also, it's a question in our traditional approach of court proceedings where the legal experts in the courtroom govern the process, and often there can be just a conversation between the lawyers and the magistrate or judge. And where is the message of relatedness there in relation to the parties to the proceedings? So why should we be concerned in courts or in the law generally with autonomy, competence, and relatedness? Well, these values are also tie into procedural justice research as to why people obey court orders, why people respect the court. And I'll comment on that in a minute. Also, research in the areas of drug rehabilitation and offender rehabilitation support the value of autonomy. And in relation to that second point, I'll refer to work by Carlo Di Clemente and Chad Maruna. Carlo Di Clemente would be familiar to many of you, as he is one of the ones who developed the trans-theoretical stages of change model, which we use in drug court, and also it's used, of course, in different sectors of the healing professions these days. So procedural justice concerns why people obey the law. Tom Tyler and others have done research on procedural justice, and their research has found that people are more likely to obey a court or police officers, even if the decision is contrary to what they wanted, if certain factors have been promoted. So they've been able to present their case, have been listened to, and their story has been taken into account in making the decision. So in that regard, it's showing that a person is to some degree exercising autonomy, that they're involved in the decision-making there. And the fact that their story has been taken into account and validated respects the principle of competence, in my view. And also the whole process, if they're involved in the process, that promotes the principle of relatedness. So the other factors, they've been treated with respect. The decision maker shows they're concerned about the welfare and intend to treat them fairly. Again, these factors tie very readily into those principles of autonomy, competence, and relatedness. So I would argue that if we're able to promote those principles within the court system, then we're more likely to have people respect the decisions of courts and to follow them, even if the decision is adverse. One of the things that therapeutic jurisprudence has taken issue with over the years has been paternalism. It is the opposite of autonomy. It's an approach where the authority figure tells the person that what is good for them, what they think is good for them. Effectively, it undermines competence and relatedness. To some degree, it undermines autonomy. It's essentially saying that you're not competent to make enough to make good decisions about your own life, and we need to make them for you. And that sort of authoritarian sort of dictate, in my view, undermines the principle of relatedness, which is more, as I've commented, an each-way process. Therapeutic jurisprudence suggests that paternalistic approaches promote resistance to positive behavioural change. Okay, so Carlo Di Clemente did some research on why behavioural change happens, particularly in relation to substance misuse. And his research shows that some people give up using substances of their own volition, using their own strategies. It's called natural or self-change. But the bulk of them who do so through a combination of things, through natural or self-change, applying their own strategies, and support services, treatment and support services. So a combination of extrinsic and intrinsic processes. I just wanted to comment also about Maruna's research, which ties into the principles that self-determination theory respects. Maruna did a study on why some people desist from committing crimes and others do not. And what he found was that those who desisted found that they had a substantial degree of control over their lives, a sense of control. They had a purpose in life. Whereas those who did not desist assessed their position as dire. They didn't think that they had any prospect of being accepted in the mainstream or of having any success. And if that was the case, why would they engage in any form of behavioural change? Okay, I'll just see. So, first of all, people's story about themselves is important. And my reading of Maruna's research suggests that where there are heightened degrees of autonomy, competence, and relatedness, then you're more likely to desist from offending than those who have the opposite. So if the justice system undermines those principles of autonomy, competence, and relatedness, then it undermines basic principles that lead to positive behavioural change. I just want to quickly comment. This is I get on my soapbox and give a talk about why we should be calling drug courts, family violence courts, community courts, solution-focused courts rather than problem-solving courts. Basically because of what we've just discussed, that behavioural change happens largely through a combination of natural change and external supports. Drawing on trans-theoretical stages of change, people come into court some of the time having already started and need to continue well beyond the intervention of the court in terms of the behavioural change pathway. And it's not our role to solve people's personal problems. So I prefer the term solution-focused courts. And also, if you look at the 10 key components of drug courts, they're all about things that happen to people or around them. It doesn't involve actually involving them and the participants in the process. So drawing on self-determination theory, that's my proposed 11th key component of drug courts. So how do we promote autonomy, competence, and relatedness in court processes? So I just want to refer to two areas. How we actively involve defendants and other parties in the process. And also I'll briefly comment on sentencing remarks. I'm not going to give an exposition of a comprehensive outline of what should happen in sentencing remarks, just a couple of comments about what could be taken into account. Members of the public would probably think that the greatest power a court has is the power to imprison. I take the view that the greatest power we have is the power to adjourn with conditions. That way, we put off a decision and use that as leverage to help people to engage in processes that would improve their situation, most notably engaging in positive behavioural change. So the second paragraph sets out examples of where this can be considered. An additional one is where people are being asked to have be given a second chance on a community corrections order. I've used this sort of process there as well. And I would also argue it can be used in relation to respondents in family violence intervention order proceedings. I'm talking mainly about criminal in this presentation, but many of the principles can be adapted across into our civil jurisdiction as well. So how do we get involved in this sort of process? So again, engaging in a conversation with the participant rather than saying, I think you should do X, Y, and Z, and if you don't, this is what's going to happen. Having a conversation with the defendant about, if I adjourn the matter, what will you do? What action will you take? What do you want to achieve during this time? One thing I've done in some bail hearings is to have a chat to the defendant and say, if I grant you bail, what conditions do you think might help you? Rather than not involving the defendant in the conversation. Clearly, we can't use that in every case. Some defendants are not in a state where that sort of conversation can take place on an initial bail hearing. But in many cases, we can consider doing that. And instead of saying to someone, I think you should do X program, my approach is to, if they haven't mentioned that as something they want to do, I'll say something like, have you thought about doing X? Or what do you think about doing X? That way you're inviting them into the conversation, you're promoting autonomy, and you're also sending a message of competence that you value their view as to what would help their situation. You're also promoting relatedness because you're connecting directly to someone rather than through a lawyer or through directly saying to someone, you shall do X. And one of the advantages of this sort of conversation is if they agree, then they've got a stake in it, because this is something that through a conversation, they've reached an agreement about what they're going to do. So they're more likely to engage in action directed towards the achievement of what has been discussed. The other thing at court, and I'm talking about courts, but of course this can be applied by lawyers in practice, by other people, officers involved in the court process, these sorts of general approaches. But in the context of a court, if someone comes up with a good plan, then we can comment on specific aspects of it, say how we like this particular part and how we think this might help them succeed. So that has been my approach. If someone comes up with a good plan, I praise the things that really stand out as being a way forward for them. If the matter comes back when the matter comes back, then we can point to things that they've achieved, things that they said that they would do and that they've achieved. We can identify the strengths and strategies they've used to achieve what they've done. So, for example, in a recent drug court matter I had, someone stayed away from drugs even though they'd had two bereavements in a very close proximity, and they'd attended all of their appointments, stayed in touch with their case manager, and I praised their resilience, their ability to show strength and not use drugs as a coping mechanism to deal with a very difficult time that they were going through. And also in terms of when someone comes up with a plan, we can support their competence, their self-efficacy. Drug court has the advantage, we have a whole lot of reports which sets out things that people's background, things they've done in the past. But even from a plea mitigation, we can often pick out some positive things, such as when people have had periods of abstinence or where they haven't offended for some years, where we can emphasize that they've got that ability to do the right thing. So I've already probably covered a lot of what we would talk about in relation to relatedness. So involving people in the discussion, in promoting a dialogue rather than a one-sided monologue from the court to the participant. So inviting input and listening. I'll refer to a quote about listening shortly. And we can show we're listening through reflecting back some of what they've said or acknowledging things that they've said that appear to be really important with them, or giving a short summary and asking them whether what we've summarised is accurate in terms of what they've said. That way we're showing that we're listening, we're involving people, and we're showing that their views, their opinions are worthy of respect. Okay, I've already talked about the third and fourth paragraphs. The fifth, this is what we are already doing. We connect people to support programs through deferral of sentence, through KISP, through ARC, Curry Court, and Drug Court, as well as through community corrections orders. This is a great quote it's in the context of holistic lawyering by the late Stephen Keever, but it's a great quote on listening. And although this is in the context of a lawyer listening to a client, I would argue that this same thing applies to listening in court, or listening in an office at the court where a court officer is listening to someone, or whatever context. Just by giving someone their attention, you can help them perhaps clarify in their own minds what their situation is and what they need to do. Okay, I just want to talk briefly about a strategy that I use in screening hearings in drug court, and also that I've used bail hearings where people have asked for second chances on community corrections orders, and also where people want to be considered for community corrections orders. Some of you have seen the form that I've used. Basically, it sets out, it's something that they fill out, or they fill out with the help of their lawyer. It's the version 1 is the a 1-page. It has goals and then some numbers and blank lines for people to fill in what I want to achieve. And then the second half of the form has some more lines and a title, strategies, what will I do to achieve them? So it is directed to involving them, promoting autonomy, and being a vehicle to promote relatedness and competence. I've recently revised that form and added a third question. And the third question is, what will it mean for me, for those close to me and my community when I achieve these goals? So that third question is about relatedness. It also ties into what positive psychology sees as one of the essential things for a flourishing life, which is meaning or purpose in life. And so, and it ties into strengths-based approaches as well as self-determination theory. I've been using that for the last month or two in drug court. I get new people coming into drug court to fill that out in between the screening hearing and the sentencing hearing. And the third question, they all come up with really good plans, and I've been impressed with what people have done in relation to the third question as well. It allows them to think more broadly beyond their drug-using life, to think about their families and their community, and also for what it would mean for them for a life beyond that sort of drug-using lifestyle. So, so far that's been a great success for me as far as drug court is concerned. So it allows participants to tap into strong sources of motivation within themselves. It gives us a deeper insight into what motivates them and allows for a deeper rapport. It promotes procedural justice. And I would argue, promotes autonomy, competence, and relatedness. And it's a reference point for us when problems arise. So over the last few months in drug court, at times where someone is not really living up to their potential in drug court, I will refer them back to what they told me at the beginning of drug court. Before we started using the forms, I would ask people to actually tell me what their goals were and what their strategies were. And I'd refer back to my notes of that, and I'd say, you told me back on this date that you were going to aim for this, and these were the strategies you were going to use. And I said how great they were. How does your present performance fit in with that? And that way it's allowing their own goals, their own strategies, their own assertion of what they're going to do to be the reference point, the checkpoint, rather than me saying, you didn't do X, why not? So it's trying to source internal sources of motivation rather than the external force. Okay, so that's the goals and summaries exercise, goals and strategies exercise. I just want to comment about a couple of things to do with sentencing. One of the things that irks me is when I read reports of cases where a judge or another judicial officer has told a defendant that they have little prospect of rehabilitation. I'm wondering about the therapeutic effect, what someone would receive from that, and whether we're just continuing labelling theory where someone has been labelled an offender and they just continue on that cycle, another bit of reinforcement. What can be the value to the community of doing that? I would argue that if someone has to be imprisoned, then one can say that the seriousness of the offending and the need to deter you and others, notwithstanding your need for rehabilitation, justifies an immediate term of imprisonment. That sort of approach, in my humble opinion, is preferable. Anyway, even if one sends someone to prison, then I think we can take sentencing remarks, use them in a way to try and promote competence and autonomy and relatedness. We can still suggest the potential to change and refer to material before us that shows that people have had that experience in the past, that they've been able to apply good strategies, and there's no reason why they can't do that in the future. So to encourage, to promote their ability to continue to change. I referred to, in our drug court team case management meeting today, I referred to a case I had in Perth Drug Court where I was sitting in court one afternoon and my clerk said to me, there's a man in the back who wants to speak to you, but he's not on the court list. And I said, okay, he can speak to me. And so in open court, he came up and he said to the bar table, and he said, last year you terminated my time in drug court because I'd absconded over a number of months and you sent me to prison. Since coming out of prison, I've got a job, I've got my partner, we've bought a house, we've got a mortgage, and my life's back on track. And the reason why I've been able to do that is what I learned in drug court. So even though someone might go to jail, the experiences that they've had, the learnings that they've had, might gel at a future time and enable them to engage in positive behavioural change. So it's important to denounce the behaviour and the choices made and not the person. Okay, so I've talked a bit about how we can promote positive behavioural change, but there are limits in terms of us as judicial officers. And this great quote from Bruce Winnick, the late Bruce Winnick, summarises it all. All of us need to know our own professional boundaries and recognise that. And the principles of self-determination theory emphasise this importance of control that people have and their responsibility for their own lives. And the boundary that we have as judicial officers, we need to respect that as well. Okay, so in conclusion, autonomy, competence, and relatedness are arguably important for positive behavioural change and human flourishing. And I would argue that even in a coercive environment such as a court, we can promote those sorts of values. And I've given examples of how that can be done, and I'm sure there are many more. Of course, we're not becoming therapists, as I mentioned, And we're applying therapeutic approaches informed by the behavioural sciences, but we are doing those within the confines of the law, within the confines of justice system values. Therapeutic jurisprudence recognises that the therapeutic value does not trump all other values in the justice system. It's part of the mix. It informs how we can act and how we can approach things, even in a way that might lead to a severe outcome in terms of a sentence, but in a way that respects those values of autonomy, competence, and relatedness. This depends upon our exercise of interpersonal skills. And I would add that, conclude by commenting that these sorts of principles are consistent with trauma-informed practice. So it helps us to approach this important area as well. And interestingly, it ties into principles of transformational leadership, which is widely used in the community to promote peak performance in government and non-government organisations. So we're viewing our people as whole human beings with potential to address their underlying issues and to attain peak performance. For those of us who sit in drug court, we see our people graduating from drug court as making a substantial life achievement and essentially attaining peak performance in that area. So thank you all for your attention.
Thank you, Michael. Now I'll just open it up to any comments or questions.
One of the questions I have is that when people come into the courtroom, they've already been through what's probably quite a tough process through the policing process. So how does that work when you're balancing people that have been, without casting aspersions on our colleagues in a very risk management, highly controlled environment where there is no autonomy at all?
Of course, we don't have any control over what happens before people come into court. We do have control over our courtrooms, and I think it may be the other issue you've raised ties into people's previous experience with courts as well, and they may have had bad experiences over the years in terms of a coercive approach, and may be reluctant to engage with a judicial officer, and they may be reluctant to engage because of their experience with police as well. I think it takes patience. One doesn't develop rapport immediately, although in some cases it can. But if you demonstrate that you are interested in that person, that you use language that's appropriate, that you use appropriate body language, that you include people and show respect to them, then they're more likely to relax and settle into the process. And the environment that you create in the courtroom can be comfortable for people to engage, and particularly if they've been sitting watching and seeing how a magistrate or a judge has already dealt with other people, it can help them to realise that there isn't an angry man up on the bench there after all.
Thank you for that. Questions from anyone? Again, either unmute yourself and ask away, or you can put it in the chat if you prefer that.
Monica Fleck there.
Hello. This is sort of a futuristic question, but do you see the decriminalisation of personal possession of drugs at some point in Melbourne or Victoria in the future?
That gets into a political question where magistrates really shouldn't be commenting. But I note that there are some jurisdictions around the world that have taken a radically different approach. Portugal has decriminalised drugs largely. There are certain drug offences still there, but not to do with possession or use. And they seem to be getting great results.
I can see Matthew Willis there with his hand up patiently.
Yes, thank you, Magistrate Spencer. Dr. King, thank you very much for that fascinating presentation. I'm with the Neighbourhood Justice Centre. I was just interested in your thoughts on how we might measure or assess some of the perhaps less tangible indicators of success in a therapeutic context. I'm thinking of some of them, we like to impact on people's, say, well-being, and impact on, the well-being in the context of, say, their family environments and so on. How might we measure and assess those kinds of indicators?
Good question. I'm not a research scientist, but I'd have thought some qualitative research would be really useful in that area where past and even present people are involved on an anonymous basis, could be interviewed in relation to the effects that they've noticed on their lives. And I think it's a really good point, because unfortunately the politicians look at it in terms of, and the bean counters look at it in terms of pure recidivism, whereas the TJ approach goes to things like one of our drug court participants last week attended a citizenship ceremony for her sister-in-law, whereas I wouldn't have varied the curfew to allow her to do that had she not made enormous progress. We have our drug court participants who are now spending time with their children. I have one today who has now got permission to have a couple of contacts with children per week. And if he can maintains abstinence over the coming weeks, he'll get overnight contact. You can't measure that in terms of statistics, but these are the meaningful changes. We have a child now that, or children that are having fathers back in their lives, or a mother spending time with her daughters. These are things that can only really be measured through qualitative research, I'd have thought.
Great, thank you.
There's from Johnny from the chat. What are your thoughts on any value add by including lived experience mentors along with therapeutic jurisprudence approaches?
I think it's a great idea, and we already do it in drug court. One of our facilitators out at one of our programs in Dandenong Drug Court was in my drug court list at Melbourne a couple of years ago. So he's done exceptionally well. And we also have peer mentor support program running through at the drug court at Dandenong. So I think having peers involved is a really valuable program, and our participants gain a lot from it, and they speak highly of it.
I even know myself, Michael, when you're in court, if you don't have a formal peer support program, but just even people hearing from other people about how well they're doing in court, whether it's on my judicial supervision days or if I'm in ARC or Curry Court, and people are sitting watching and they can see how well other people are doing, and it's that like informal inspiration. Do you find that?
Well, we find that with drug court. Like one of the feedback sheets today for a participant referred to someone wanting to get into a particular work program because he'd seen another drug court participant do really well in it and was inspired by him. And we regularly see sheets where one participant is inspired by the graduation or the achievements of other drug court participants.
Great. And a question from Rosie here. How do you balance autonomy for the respondent in family violence jurisdiction with the need for autonomy and control for the applicant?
Very good question. I would do it, well, where I have used this sort of approach in the past has been more about encouraging participants respondents, I should say, to engage in men's behavioural change programs. So engaging in a conversation with them to explore the value of engaging in such a program, and trying to promote them voluntarily engaging in the program. The dynamic with respondents, of course, is often the time where they resign their own autonomy. They blame it on someone else, the behaviour. They blame the victim. They don't assume autonomy. They give up the power they have to engage in positive behavioural change. So I get into a conversation with them in court to try and help them to assume the responsibility for making things better in terms of their own behaviour and the protection of victims.
I suppose that's what you were talking about before, also about that autonomy doesn't mean a lack of accountability.
No.
So that
No, in fact, I would argue that it requires accountability, because if there isn't accountability, you're not being responsible for your own actions, and you're blaming the environment. You're giving up the power you have to make positive decisions.
anyone else? Oh, hold on. We got Emily asked, some of the behaviour change strategies are similar to those used by community corrections, although they rely on acceptance of guilt. How could these be incorporated pre-sentence?
Well, we already do that with deferral of sentence, with KISP, and and adjourned undertakings at times too. All of those we can impose conditions. All of those we can enter into a conversation with the relevant defendant and help them or promote them coming up with strategies to engage in positive behavioural change or to otherwise address issues. I mean, this sort of strategy can apply from the smallest matter to the biggest. I've used it in council prosecutions where someone's left a whole lot of rubbish in their yard and not cleaned it up. And I've entered into a conversation with a participant about how do you think it's affecting the neighbourhood, how it's affecting your life, what do you think could be done about it? And often it leads to the conversation that they're prepared to clear it all away. And I said, how long do you need for that? And then, okay, I'll adjourn it through to another date. If you do all of that, I'll release you on an undertaking rather than imposing a fine. So you can deal with it in a whole variety of matters.
Excellent. And from Anthony, last question, how do we better measure the experiences of court users from disadvantaged communities, those from non-English backgrounds, those with mental health issues and disability, noting the current Disability Royal Commission occurring?
Again, I think that comes back to qualitative research. In terms of how we approach things, I think our court is getting more and more sensitive to the needs of the different communities that we serve, and we try and undertake processes that are more inclusive. And these sorts of processes in court are more inclusive by their very nature. So hopefully it's less alienating for those members of those particular communities. In terms of what the effects are on them of the justice system, then I think that is a matter for qualitative research.
Great. Well, great questions, everyone. I think, Dr. King, you've really engendered some discussion and thought here, and it's something we can all take back in our own way, whether we're security at the front of the court, registrars at the front desk, the lawyers, case managers, judiciary, whatever part we play in the process, that if we're building in those concepts that build agency and autonomy, competence and relatedness, and thinking about how we can build that into our little piece of work, then we're going to have better results for the individuals, but also greater legitimacy and confidence in our system. All right, have a great afternoon and thank you for joining us, and stay tuned for the next exciting Consider This series.